Sports fans have been getting more cynical, and every time you see a bad play, a bad call, or a missed free throw, people all say the same thing. This game is rigged, or at least the thought occurs. And can you really tell them, look them in the eye, and say that they're wrong? No. And the unfortunate truth is that it's only going to get worse. Today, I'm going to ask, why did the Supreme Court do this to us? Now, before we get into why and how the Supreme Court did this, we have to go back. For most of American history, sports betting has lived in a strange push and pull with our legal system. Gambling was widespread in the 1800s, but by the end of the 19th century, it was largely banned across the entire country, driven by moral reform movements and fears of corruption. But those fears were not abstract. The 1919 Black Sox World Series, where Chicago White Sox players conspired to throw the championship, became a national symbol of how gambling could undermine the integrity of sports. A few decades later, the nation was again shocked in the early 1950s when several college basketball players were convicted for shaving points, a scandal so severe that historians have said it nearly killed college basketball altogether. These episodes cemented a powerful idea in the American mind. Gambling was not just a vice, it was a threat to fair competition and America's favorite pastimes. Now, at the same time, economic reality kept pulling states back towards gambling. During the Great Depression, states loosened prohibitions and allowed pari-mutuel betting on horse races to raise revenue. By the 1950s, churches and nonprofits were permitted to run bingo games, and in 1970 New Jersey launched a state lottery, quickly followed by many other states. By the late 20th century, gambling had become deeply embedded in state budgets, even as sports betting remained mostly taboo. Now, eventually, Congress stepped in with the Professional and Amateur Sports Protection Act of 1992, referred to as PASPA. Lawmakers argued that legal sports betting posed a unique threat to the integrity of professional and amateur sports, especially when it came to college athletics. They feared a nationwide patchwork of state laws normalizing betting. PASPA did not create a federal sports betting regime. Instead, what it aimed to do was freeze the status quo by barring most states from authorizing sports gambling, while carving out exceptions for a few states like Nevada that already allowed it. Essentially a grandfather clause. The result was a federal attempt to protect sports by telling states what they could not legalize. Now, this choice would eventually trigger a constitutional showdown. All of this had set the stage for the modern legal fight, which culminated in 2018 in Murphy versus the NCAA before the Supreme Court. The only thing was, the court wasn't interested in gambling. Not even a little bit. For the court, they were interested in something called anti-commandeering doctrine, of which the Supreme Court said the following. The anti-commandeering doctrine may sound arcane, but it is simply the expression of a fundamental structural decision incorporated into the Constitution, i.e., the decision to withhold from Congress the power to issue orders directly to the states. When the original states declared their independence, they claimed the powers inherent in sovereignty. In the words of the Declaration of Independence, the authority to do all acts and things which independent states may of right do. Thus, both the federal government and states wield sovereign powers, and that is why our system of government is said to be one of dual sovereignty. All of that is to say, the Supreme Court was focused on states' rights. As to the PASPA, Congress's protection against sports betting and gambling, the court said the following. The PASPA provision at issue here, prohibiting state authorization of sports gambling, violates the anti-commandeering rule. That provision unequivocally dictates what a state legislature may and may not do. And this is true under either our interpretation or that advocated by respondents and the United States. In either event, state legislatures are put under the direct control of Congress. It is as if federal officers were installed in state legislative chambers and were armed with the authority to stop legislatures from voting on any offending proposals. A more direct affront to state sovereignty is not easy to imagine. The court could not have made its admonishment more clear. PASPA was in fact not constitutional under their analysis. But the court did leave open the possibility for other forms of regulation, ones that would be constitutional, to which the court said the following. Congress can regulate sports gambling directly, but if it elects not to do so, each state is free to act on its own. Our job is to interpret the law Congress has enacted and decide whether it is consistent with the Constitution. PASPA is not. What followed the court's opinion in 2018 was rapid state legalization. There was an explosion of betting apps and marketing, and organized crime started adapting, not disappearing. Regulation lagged once again behind new innovation. Unfortunately, this problem isn't going anywhere. As much as I would love to sit here and tell you that it's all the fault of the Supreme Court, it just wouldn't be true. The truth is, we all played a role in this. From the Supreme Court to the state legislatures that legalized it, to ourselves, the consumers, who use it and make it so lucrative. If you enjoyed the video, I hope you'll press like, I hope you'll subscribe, stick around. As always, have a good rest of your day. Take care.